Good afternoon to you. We will now continue with the Constitution. So in the last class, we have seen, in fact in detail, the case relating to Golaknath versus State of Punjab and also the landmark judgment of the Supreme Court with regard to the amendment of the Constitution. The court has overturned its earlier decisions in Shankari Prasad versus Union of India and Sajjan Singh versus State of Rajasthan cases. As you know, in both these cases, the Supreme Court held that the Parliament has absolute powers to amend any part of the Constitution, including the fundamental rights, and also that the term law in Article 13 does not include the law made to amend the Constitution, because the constitutional amendment law is made by the Parliament in exercise of its constituent power. However, as has been discussed in the last class, in Golaknath case, Supreme Court held that the Parliament has no powers to amend the Constitution, and also that the term law in Article 13 applies to both ordinary law and also the constitutional law, and therefore the embargo, that is the prohibition in Article 13, applies to constitutional amendments also. This is the most important part of the Golaknath versus State of Punjab case. In relation to the Supreme Court decision in Golaknath case of 1967, Parliament sought to reconcile the question of whether the constitutional amendments were law under Article 13. Accordingly, the Parliament brought out 24th Amendment Act 1971 to overcome the difficulties posed by the Supreme Court. Following amendments were made. Number 1, a proviso in clause 4 of Article 13 was inserted to exclude the constitutional amendments from the ambit of Article 13. In addition, Article 368 underwent 3 amendments. Number 1, the caption was changed, adding the power of the Parliament to amend the Constitution and procedure thereof. As you remember, the Supreme Court said that Article 368 gives only the procedure, not the power. So to overcome this problem, the caption itself has been changed, saying the power of the Parliament to amend the Constitution and the procedure thereof. Secondly, it has been made abundantly clear that the Parliament can amend any provision of the Constitution by way of addition, variation, repeal after following the procedure given in Article 368. This is the second very important development. Thirdly, President of India has been obligated to give assent to the constitutional amendment bills. Here it has been made obligatory on the part of the President to give assent to any constitutional amendment bill. In other words, he cannot exercise absolute veto, suspense veto, or so-called pocket veto with regard to constitutional amendment bills. In short, through these amendments, Parliament has nullified the decision of the Supreme Court and ensured that the amendments could not be reviewed again by the court, even if they violated the fundamental rights of the citizens. Now came the most famous and most popular case of Keshavananda Barati versus State of Kerala. This case is also called Fundamental Rights Case, 1973. To be precise, 24th April 1973. The facts of the case is His Holiness Swami Keshavananda Barati was the head of Yednir Math near Kasargod in Kerala. He is a very popular man. Kerala Land Reforms Act had affected the property of his religious institution, leading him to challenge the State Land Reforms Act in Kerala of 1970. While the proceedings were underway, the 29th Constitutional Amendment Act 1972 added Kerala Land Reforms Act under Schedule 9, extending the judicial immunity to the Act. Nani Palkiwala, who was defending the case of the Math Keshavananda Barati, he is the very eminent lawyer, very most eminent lawyer of the time. He challenged the validity of three amendments. Number one, 24th Amendment Act, 25th Amendment Act, 29th Amendment Act of the Constitution. 24th Amendment Act I have already discussed. Now 25th Amendment Act 1971 made a very drastic change in the sense Article 39B and Article 39C, the most classically socialistic provisions of directive principles of state policy, were given precedence over the fundamental rights in Article 14, 19 and 31. These three have been made subservient to the Article 39B and C. This also took away the powers of the court to decide whether the law was actually passed to further the policy laid down in the directive principles of state policy. 29th Amendment Act, as I have already told you, inserted the Kerala Land Reforms Act in Schedule 9, extending judicial immunity. The most critical questions posed before the Supreme Court are: number one, to reconsider the decision of the court in Shankari Prasad, Sajjan Singh and Golaknath case. Three cases Supreme Court has to review. Secondly, how much amending power, if at all, has been given by the Constitution to the Parliament to amend the Constitution. Number two. Number three, whether the court has powers to review the Constitution. Number three. Number four, whether Article 13 includes the constitutional amendments within the purview of the term law. This is the fourth one. Now, 13 judges, the largest bench so far, sat for almost 5 months to decide these issues. The verdict had 11 separate opinions, with each judge expressing divergent opinion on each issue. For the first time in the history of judiciary, the judges gave a summary of their decision, which 4 judges refused to sign since the summary was allegedly inaccurate. All the judges held that 24th Amendment Act 1971 was valid, as Article 368 confers the powers of the Parliament to amend all or any of the provisions of the Constitution. The second part of the 25th Amendment Act, that is removing the judicial review, that is no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy was declared invalid. That was declared invalid because judicial review later on, it has been made as a basic structure, it is approved, that portion has been made invalid. The 29th Amendment Act was considered to be valid. That is, the Kerala Land Reforms Act, which had been included through 29th Amendment Act, has been declared valid. In other words, the petitioner did not get any relief. Secondly, however, 7 of the 13 judges, majority, 7:6. So 7 of the 13 judges, including the Chief Justice of India, Justice Sikri, who signed the summary statement, declared that the Parliament constituent power was subject to inherent limitation. That is, the constituent powers of the Parliament were subject to inherent limitations, upholding the validity of Clause 4 of Article 13 and also the corresponding provision in Article 368 within bracket 3, that is the Clause 3 of Article 368, inserted by 24th Amendment Act 1971, the court settled in favor of the view that the Parliament has powers to amend any part of the Constitution, including fundamental rights. The court has also overruled the decision in Golaknath case. These two major, decision in favor of the government. Supreme Court most importantly held that the Parliament cannot use its amending power under Article 368 to damage or destroy or abrogate or change or alter or emasculate the basic structure of the Constitution. Significantly, the six judges who are in minority held that the Parliament has powers to amend any part of the Constitution. The term basic structure was first used by the counsels while arguing for the petitioners in Golaknath case. I have already told about the Justice Madolkar who advocated hinted about the need for basic structure. But it was given an expression in the text of the verdict of the Supreme Court in Keshavananda Barati case. The basic structure term was not defined in the Constitution. In other words, adopting the basic structure method, Supreme Court held that the expression amendment does not deface the Constitution to such an extent that it loses its identity. Another point is the word used is amend. Amend means change. You can change, but subject to certain limitation. You cannot change completely as to destroy the entire fabric of the Constitution. You can change, but only to a limited extent. All the constitutional amendments enacted after this date, that is 24th April 1973, that is the date of judgment, would have to pass the basic structure filter created by the Supreme Court. There was no unanimity of opinion in what constitutes basic structure. Chief Justice of India, Justice Sikri, identified supremacy of Constitution, republican and democratic form of government, secular character of the Constitution, separation of powers among the three organs of the state, and federal character, etc., constitute the basic structure. Justice Shalat and Justice Grover added two more elements. Number one, the dignity of individual, secured by the fundamental rights, and mandate of the welfare state and unity, integrity of the nation. Similarly, Justice Hegde and Justice Mukherjee included sovereignty of India, democratic character of unity of the country, individual freedom, and egalitarian society also constitute basic structure. Now, the basic structure thus was given prominent importance in the history of Constitution. So, in other words, basic structure includes what has been listed in preamble. With this, we end the Keshavananda Barati case. From tomorrow, next class onwards, we will continue the Minerva Mill case and Vamana case. Both the cases are important. With that, we will end the constitutional amendment.